Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer. And I was asked a question recently. I thought it was a great question. It said, you have videos about different things, but do you have something that specifically talks about how do you respond to a collection lawsuit? Whether that's an answer or a motion to dismiss, how do you do that? And I thought that was a great question. So let's look at kind of the big picture of a collection lawsuit. First, we start off with the lawsuit or the complaint is filed, and then it's served on you as the defendant. And then you either respond within the time limits, or typically there's a default judgment that's entered against you because you didn't show up. You didn't respond, so you lose by default. Maybe there's discovery where we're asking each other for documents and asking each other questions, maybe taking depositions. Maybe there's what's called summary judgment, where one side's trying to win before trial, and then you have the trial. Now, we'll focus in on really that third stage that I've listed here, the respond or default judgment. Because when your time limit starts, and if you miss that time limit, then you can lose. So this is the biggest danger that you face early in the case. So you've been served with the lawsuit, and so this is the moment of danger for you. So here's some things to think about. You have to understand the time limits in your state, not another state, your state. You have to understand the option of answering or filing a motion to dismiss, and then evaluate, well, which is better in your court, not somebody else's court, your court. Then whatever it is you're filing, an answer or a motion to dismiss, you have to prepare it. Then you have to file it in court. Usually you have to serve the other side a copy of what you prepared. And then you want to follow up to make sure you didn't miss anything. So let's look at each of these. So what are the time limits in your state? Not somebody else's state, your state. Is it triggered by being served? Normally it is, but again, you have to check in your state. So being served will mean different things. Again, you have to check in your state, but that may mean the papers are handed to you. It may mean certified mail. Maybe it's giving it to an adult that lives in your house. There's all different ways of being served. So does that start the clock ticking on you filing a response? And if it does, what's your deadline? Is it 7 days? Is it 14, 21, 28, 30? What is it? It varies by state. And even within a state, it varies by court. So I practice in Alabama. If you're served in small claims or district court, you have 14 days to respond. If it's in circuit courts, you have 30 days to respond. So how do you figure out in your state what the deadline is? Because I'm assuming you're not hiring a lawyer. If you're hiring a lawyer, the lawyer will tell you this. And I do recommend that you get with a consumer protection lawyer in your state. But let's assume for whatever reason that's not possible or it's not happening. We'll look at the summons. Typically, the summons will sit on top of the complaint, and it will tell you literally you have this many days to respond. Also, look up the rules of civil procedure in your state and see what the deadline is. And if you're in a small claims type of court, it could be called something different. Sometimes it's called Justice of the Peace Court, or I don't know. There's all different names for it. But if it's kind of the more casual, laid-back court, you may have a completely different set of rules. So you've got to study those. Now, 2 warnings. If you're acting as your own attorney, you have to understand the rules of civil procedure. I know it's not exciting to read that stuff, but if you're playing this game, you must understand the rules of the game. And the rules of civil procedure apply no matter what type of case it is. Okay, whether it's a car wreck or a collection suit, whatever it is, the rules of civil procedure give us the rules. And knowing those gives you an advantage if your opponent does not know them. Well, let's flip that around. The collection lawyer that literally files 500 or 1,000 lawsuits a month, sometimes a week, you would think they would know the rules of civil procedure. So if you don't know them and you're acting as your own attorney, you are at a terrible disadvantage. You have to put the time in to understand the rules of civil procedure. Now, let me emphasize this again, because this is where a lot of people get off track. They start thinking about the rules of some other state. It doesn't matter in another state. What matters, the rules of civil procedure in your state. That's what matters. Okay. Now, do you file an answer or a motion to dismiss? Well, the first step is, in your rules, are you even allowed to file a motion to dismiss? Because if you're not, you don't need to waste your time. And especially, if somebody's selling on the internet, oh, here's a motion to dismiss. I have the perfect motion to dismiss. I would be incredibly skeptical of that. Okay. Same thing with an answer. But if you're going to buy something, at least make sure you can even use it before you buy it, and find out where that person, if they're selling you an answer or a motion to dismiss, well, what state is that from? Okay, so let's make sure you can do it. And let's go through kind of what the differences are. So an answer is you are literally answering, responding to the allegations of the lawsuit. Maybe they say, on this day you took out a credit card. Well, do you admit or deny that? You're responding to it. You put your affirmative defenses. Those are defenses that say, hey, I might be guilty of what you say, but you still lose because statute of limitations has expired, or we've already settled this debt, or whatever it may be. If you're filing a counterclaim, which I personally don't do that, or it's very rare I do that, can you file a counterclaim in your particular court? And if so, you can typically do that with an answer. So it's called an answer and counterclaim. Now, when you file an answer, particularly just an answer without a counterclaim, you're normally not revealing your strategy. You're just responding, and you may put things in there like, I do not owe the plaintiff, the one that sued you. The plaintiff does not own this debt. The plaintiff doesn't have the right to sue me. You're not really giving much away by saying that. And then the next step is the case moves forward, because we have the lawsuit and then your answer. And the numbering system can differ by state, but if you're following kind of the federal rules of civil procedure, that numbering system, which most states do, this is typically going to be Rule 8. But again, if you're in small claims court, that can be a totally different set of rules. Now, what's a motion to dismiss? A motion to dismiss is attacking the complaint. So you're not even responding to it by saying, yes, I admit that I had this contract, or my car was repossessed, or whatever. You're just attacking the complaint. And typically the rules say nothing outside that complaint can be considered. So you can't go, in most states, again, learn your rules, okay? But for example, where I practice in Alabama, we can't file a motion to dismiss and then start attaching a bunch of stuff, okay? That's the general rule, because we're only looking at the complaint. From the face of the complaint, is it obvious that there's no way that the plaintiff, the collection company that sued you, can win? And so normally the case does not move forward until after there's a hearing on your motion to dismiss. So here's a practical piece of advice. You got to know whether your judges ever grant these. Okay? If your judge will never grant this, then why are you doing it? I mean, you may just be delaying things, but does that really benefit you? And are you revealing your strategy and giving them an opportunity to be better prepared at trial? And so typically under the rules, this is under Rule 12, and then you'll find a subsection B, and then there's a whole list of them. But the normal one is 6, which is a failure to state a claim. So that's the typical motion to dismiss. So whatever your response is, whether it's an answer or a motion to dismiss, find out in your court what's the acceptable format. There may be a form that you can find. So just Google, if you live in Alabama, put Alabama form answer. If you live in Texas, Texas form answer. There may be an official form that you can use, or there may just be a custom of what the judges like to see. So you've got to ask around, got to find out. And then you type it up. I mean, you can handwrite it, okay, but I have terrible handwriting, okay, so that wouldn't be a good option. You may have beautiful handwriting. Maybe that's a fantastic option, but usually people are going to type it. Now, normally you would have the style of the case. Well, what does that mean? Well, that lists the parties. So Midland Funding versus, Joe Blow, okay? The name of the court. So this might be in the District Court of Jefferson County, Alabama. We're in the District Court of, whatever, Pasco County, Florida. Okay. So you want to identify who the parties are, what the court is, and the case number. And the whole purpose of this is so that your document that you want to file in court, the clerk of the court who keeps up with all this knows, well, which sort of think physical folder. It may all be electronic, but which folder, which case does your answer or your motion to dismiss go in? We have to tell the clerk, here's the name of the parties, here's the name of the court, here's the case number, so they get it in the right file. And then typically you would sign this. And again, you have to know for your state, do you put a certificate of service? That's a general sort of description of something that says, hey, I promise on this day that I have mailed a copy of this document with postage prepaid to the correct address to the following people. And then you sign that. And then I would make several copies, or the easy way is you print several copies and you just sign all of them. Well, then what do? Well, then you go file your response in court. So you need to know, where do I go file it? Okay. Which courthouse? Are there multiple courthouses in your county? Well, which one do you go to? Can you file it electronically? If so, do you have to set up a password, a username? Does it cost money? How does that work electronically? Especially as I'm recording this is in November. We're still in the middle of COVID-19. Is your courthouse open? Now, sometimes the courthouses are open, but you're not allowed to go to the clerk's office, which is seems to me a little bit of a contradiction. But I've been in those courthouses where they're open, but at least non-lawyers not allowed to go into the clerk's office. They have a box sitting there and they say, put your filing in here and trust us, we'll take care of it. That's a little weird to me. Okay. But figure out before your deadline is up, how do you get this thing filed? Do you mail it? Do you take it in person? Do you do it electronically? And however you file it, you want to make sure you have proof of what you filed. In other words, like literally the document you filed and when you filed it. Because if you just file it and you have no proof and they say, well, actually you did not file an answer or a motion to dismiss. You're like, yeah, I did. They go, where's your proof? Well, it's in a Word document on my computer. That's not good enough. You want to be able to prove exactly what you filed. Then they may say, oh yeah, you filed an answer, but you filed it 2 days too late. You're like, no, I didn't. I filed it on day 14 if you have 14 days to answer. And they say, well, prove it. Well, you want to be able to prove it. So here's the normal way. Again, COVID's kind of altered this some. But normally you would walk into the clerk's office and here's my answer. And if I was doing it, I would take in the complaint and the answer so you can show it. And look, if this is true, you say, look, I've never done this before. Am I in the right place to file this? They look at the complaint, look at your answer. They go, yep. And you say, okay, here it is. And I have an extra copy. Would you guys stamp this as being filed so I can have proof that it was filed on this day at this time? Normally there's a little machine that will say, November 18 at 3:33 p.m. And you may want to do 2 of those, okay? And one of those we'll send to the other side typically. But you want to make sure that you have proof of what you filed and when you filed it. Occasionally I have seen people file an answer and the court loses that answer. And so the court thinks that you never filed a response. And so then if the other side didn't get a copy, and they file for default judgment, the judge goes, yeah, you didn't respond. So you want to be able to say, no, here's my copy where I did respond. And then I would just double check, triple check, make sure you filed it properly. Well, if this is a requirement, serve a copy on the other side. That means to send a copy to the other side. So what do your rules say? Most places say mail is fine. It doesn't even have to be certified mail. But you need to know, what are the rules? Can you email it? Do you mail it? Do you fax it? What's considered proper service? Is there some magic language you have to use? Like in Alabama, typically it says, I hereby certify that on this day I have sent this postage prepaid, properly addressed. Now, as a practical matter, we never do that because for, 15 years we've been doing everything electronically all over Alabama. But if you were doing it by mail, you would put some language like that. Just find out, is there some magic language you have to use? If you do have to do this certificate of service, have you signed it? Is that a requirement that you sign? In other words, kind of promising I've actually done this. And whatever you're required to do, whatever you promise that you've done, make sure you do it. So if you say, I promise on November 18, 2020, I put a copy of this in the mail. Well, don't wait a week. Put in the mail on November 18. Okay. So if you say you're doing it, do it. And you can always follow up with the other side. So in this context, the collection firm, and say, hey, I just want to make sure that you guys got the copy of the answer that I filed. And look, I would document very carefully. I'm calling at this time. I spoke with Susie at the front desk. And if she says, we don't know, say, well, can you find out? Is there somebody I can talk to? And they may just say, well, call back. Well, make sure you call back and document all this. So if any issue comes up about, did you serve the other side? Did you file an answer? You can show the judge, look, I was doing everything possible. Follow up with the court. Make sure that they got your answer. Follow up with the other side. Make sure that they got a copy of your answer, your motion to dismiss, so that the judge says, okay, even if there was some mistake, this person has been doing everything possible to make sure they're dotting every I, crossing every T. Okay, so what's next? Well, next you want to follow up with the court. Make sure you don't miss any deadlines or any hearings. So was your response received by the court? Did the other side get your response? So how are you being notified by the other side and by the court? Is it by mail? Is it by email? Is this done electronically? Do you have to check your mail? How are you getting this stuff? Okay. And be on the lookout for this. Okay. So example, you file a motion to dismiss. Well, typically there'll be a response from the other side. Did you get that? Do you have a right to then file a reply to it? What about a hearing? Normally there'll be a hearing on this. Well, are you getting notice of that? Because it'll tell you, be in the court at this day and time, or do a Zoom hearing. Here's the login. Here's the password. So when you get these responses or these court notices, a lot of times people say to me, well, John, the court has to send it to me by certified mail to make sure I get it. Not where I practice. They just drop it in the mail to you. Okay. Well, it may be a full-size envelope. It may be like, at least in Alabama where we get voter registration, it's like a little postcard looking size, and you sort of tear off part of it and open it up. Well, that's very easy to get mixed in with junk mail. So if you're in a lawsuit, you're representing yourself. My suggestion is you guard that mailbox, okay? Anybody that gets the mail in the house, make sure nobody throws anything away without you looking at it. Because it could be stuck between the coupons, okay? Kentucky Fried Chicken and the Pizza Hut ad. It may be stuck in there, so you got to check everything. Check your mail. Check your email. If you haven't heard anything in a while, contact the court. Hey, do you show any notices going out to me? Okay, because here's what you don't want to happen is the court sends out a notice and says, we're having trial, on December 1st, and it's November 29th, and you haven't gotten that. You want to make sure you're checking, okay? And you also want to make sure that you are complying with the rules and with the deadlines, okay? So the rules might say you have 7 days to do X, Y, Z. Well, maybe something's come up. Maybe you're sick. Let the other side know. Let the court know. Maybe there's a hearing, a trial, and you're out of town, or again, you're sick, or some problem is coming up. Let the other side know. Let the court know as soon as possible. Hey, I've got a problem. I find that most lawyers are very reasonable to deal with. Most judges are very reasonable to deal with if you tell them as soon as you know about the problem. If you have court 45 days from now and you're out of town and you wait till the day before to tell the other side and the judge, they are not going to have much sympathy. But if you tell them way ahead of time, most of these guys are very nice to deal with, okay? The lawyer will be nice. The judge, she'll be nice. I mean, people are typically pretty reasonable, but you need to be reasonable. Don't wait till the last minute. So I hope that you found this helpful. And if you have any comments, put those below, and I'm happy to try to answer those. And if you know somebody that might find this to be helpful, feel free to share it with them. Okay, guys, you have a great day. Talk to you soon. Bye-bye.